when an overzealous HOA Karen tried to drag me into a lawsuit for refusing to join her HOA. She thought she had the upper hand. What she didn't expect was that the entire HOA was built on shaky legal ground, and one bold move in court would bring it crashing down in an instant. It all started with a letter that looked unusually official for something that was supposedly just community-related. My address was neatly typed at the top, and beneath it, in bold letters, was a demand that I immediately register as a member of the Homeowners Association. At first, I assumed it was a mistake, because I'd bought my property specifically because it wasn't in any HOA's jurisdiction. That freedom was a big part of why I moved here in the first place. But as I read on, the tone became increasingly aggressive, claiming that my property was part of their community covenant, and that by owning it, I was automatically subject to their bylaws, fees, and regulations. They even attached a schedule of payments I was supposedly behind on, including late fees for months when I didn't even own the house yet. At the bottom was a signature from the HOA president, who I would soon learn was the infamous Karen of our neighborhood. She had a reputation for micromanaging everything from the color of someone's mailbox to how often people cut their grass. Neighbors quietly warned me that she enjoyed the power of the HOA a little too much and had a habit of inventing rules if the existing ones didn't give her the control she wanted. Her letter stated that I had 7 days to comply or face fines, which would be pursued through legal action if necessary. I decided to ignore it, thinking it would go away once she realized her mistake. But instead, the situation escalated. Karen showed up at my front door, clipboard in hand, speaking to me as if I were a delinquent tenant rather than a homeowner with no ties to her organization. She waved papers in my face, claiming they proved my property was within HOA boundaries. I calmly told her I'd reviewed my deed, my closing documents, and my property map. There was no HOA mentioned anywhere. She dismissed that, insisting that the community rules apply to everyone in this area, even though my home sat on a completely separate plot that wasn't connected to the development her HOA governed. Within a week, more letters arrived, each one more hostile than the last. They accused me of failing to maintain my lawn according to community standards, leaving trash bins visible for more than 24 hours, and parking unauthorized vehicles in my own driveway. The absurd part was that my lawn was neatly cut. My trash bins were stored behind a fence, and the unauthorized vehicle was my registered pickup truck. These accusations made it clear that this wasn't about enforcing any real standard. It was about Karen exerting authority where she had none. I started hearing from neighbors that she'd pulled similar stunts with others, especially newer residents who didn't yet understand the legal limits of the HOA. Many of them had paid the fines just to make her go away, even if they weren't actually bound by her rules. This emboldened her to go after more people, and now she'd set her sights on me. I refused to back down because I knew caving in would only encourage more harassment. The final straw in this first stage of her campaign came when she taped a notice to my front door stating that I had been officially added to the HOA registry and that monthly dues would be charged starting immediately. It was pure fantasy. There was no legal mechanism for her to unilaterally make me part of an HOA, but the tone of the letter was meant to intimidate. She even listed penalties like lien filings and foreclosure, implying that she could take my house if I didn't pay. It became obvious that this wasn't just a misunderstanding. This was a calculated move to bully me into submission. She wanted me to believe she had the legal power to control my property when, in reality, she didn't. Her first line of attack was pure intimidation. Aggressive demands, fabricated violations, and the hope that I would be scared enough to pay without asking questions. Unfortunately for her, I wasn't about to make it that easy. The letters didn't stop. In fact, they started arriving more frequently, sometimes 2 or 3 in a single week, each one more absurd than the last. They were printed on HOA letterhead and signed with Karen's signature in dramatic looping cursive, clearly meant to look intimidating. Each envelope carried that same self-important tone, like they were official government notices rather than just the ramblings of an overzealous neighborhood busybody. The supposed violations they accused me of became increasingly ridiculous. One claimed that my grass was too tall by community standards, even though I had mowed it just 2 days before the letter arrived. Another alleged that my mailbox was non-compliant because it didn't match the exact style used in the HOA subdivision down the road, as if my home was somehow obligated to copy their aesthetics. It wasn't just the content of the letters, it was the way they were worded. They used legal-sounding jargon like pursuant to Community Covenant Clause 8.4 and in violation of Article 12, Section C, to make it seem like these rules applied to me. But when I cross-checked my property documents, those so-called clauses didn't exist anywhere in relation to my land. This was pure fabrication, designed to make me feel trapped in a web of regulations that were never mine to begin with. It was obvious Karen had no problem inventing infractions if it meant putting me under pressure. Then came the fines. One letter included an itemized statement of my outstanding balance for the month, hundreds of dollars in charges for alleged violations like failure to landscape, improper waste disposal, and parking an unapproved recreational vehicle. The so-called RV was actually my cousin's small camper trailer, parked on my driveway for a single afternoon before we hauled it to his property. The claim about improper waste disposal referred to a single recycling bin that had been blown over by a storm. The charges were petty, but the total was designed to look overwhelming, as if they were preparing to make an example out of me. Karen didn't just rely on paper intimidation. She started patrolling the street like she was some sort of neighborhood sheriff. I'd see her slowing her car to a crawl in front of my house, sometimes stopping entirely to write in her little notebook. If I stepped outside, she'd pretend she was just passing by. But it was obvious she was documenting things to add to her growing pile of accusations. I even caught her taking photos of my property from the sidewalk, trying to collect evidence of these imaginary violations. The irony was that several actual HOA members in her own subdivision had messy yards, peeling paint or broken fences, but she seemed completely uninterested in enforcing any rules on them. Her focus was squarely on me, the outsider who dared to live free of her HOA's grasp. It became clear that this wasn't about community improvement. It was about control, about proving that she could extend her reach beyond the borders of the HOA and pull in anyone she pleased. Neighbors started telling me their own stories of how Karen had tried to bully them into compliance over the years. Some had paid up just to avoid the hassle, even though they didn't technically have to. One guy down the street confessed that she'd slapped him with fines for having the wrong type of mulch in his garden. And even though he knew it was nonsense, he didn't want to get into a fight over it. This pattern of behavior painted a clear picture. Karen thrived on intimidation and wore people down until they gave in. By now, the threatening tone of her letters had escalated to a point where she was openly warning me of legal consequences if I didn't pay her demands. She began hinting at liens, wage garnishments, and even foreclosure proceedings, trying to create the illusion that she held the power to take my home away from me. The absurdity of it all was infuriating, but I also knew it was deliberate. She wanted me to panic, to think I had no choice but to comply. This wasn't just some harmless neighborly complaint. It was a targeted harassment campaign dressed up as official HOA business, and she was relentless in her attempts to drag me into her fabricated web of authority. The day the lawsuit notice arrived, it felt different from the usual stack of HOA nonsense. This one came by certified mail, requiring my signature, and the envelope had that stiff, ominous weight of something serious. Inside was a packet of legal documents, several pages long, stamped and dated, stating that I was being sued for willful and repeated violations of community covenants and failure to remit mandatory association dues. It wasn't just Karen's name this time. It listed the HOA as the plaintiff, with her acting as president, and it bore the seal of the local court. This was no longer just a string of empty threats. She had taken the step to file an actual lawsuit against me. Reading through the paperwork, I could see she'd cobbled together every petty accusation she'd thrown at me over the past few months. Each letter she had sent was now included as evidence, along with her photographs of my property, some of which were deliberately misleading, close-ups of a single weed, a garbage bin in mid-collection, my cousin's trailer parked for a few hours. She had organized them into neat little sections, making it appear as if I had been a long-term, repeat offender of rules that didn't even apply to me. The gall of it was astonishing. What really caught my attention was how she framed the lawsuit as though my noncompliance was harming the value and integrity of the community. She claimed that my property was within the HOA's jurisdiction per annexation agreement, and that I had knowingly refused to join, despite multiple official notices. The truth was, there was no annexation agreement involving my lot, but the way she wrote it made it sound like one existed and that I was in deliberate violation of it. The goal was obvious: to overwhelm me with legal jargon and make me feel cornered into settling or paying up before the matter even reached a judge. The financial demand in the lawsuit was laughable in its boldness. She was seeking unpaid dues for the entire time I'd lived there, late fees, violation penalties, and, just to push it over the top, legal fees for the HOA's trouble in having to take me to court. The total amount was in the thousands, and I knew she was banking on the idea that the threat of such a sum would scare me into giving in. I couldn't help but think about how many people probably had fallen victim to this exact tactic. The more I read, the clearer it became that Karen wasn't just some overbearing neighbor. She was using the HOA's legal status as a weapon, even stretching it beyond its actual reach. She had elevated the fight from intimidation to full-on litigation, counting on the fact that most people wouldn't want the time, expense, or stress of fighting in court. In the following days, she made a point to flaunt her move in front of me. I'd see her at the end of her driveway, talking loudly to another neighbor about how some people think they're above the rules, and the court will set them straight. She was clearly trying to paint me as a troublemaker in the eyes of the neighborhood, someone who was selfishly refusing to contribute to the community. It was as much a public shaming campaign as it was a legal one. I kept going back to the same thought. She had no actual claim to my property, no legal tie that bound me to her HOA, and yet here we were with an official court case looming. This was a dangerous escalation because even though I knew she was in the wrong, I also knew the legal system can be slow, complicated, and unpredictable. One misstep, one missed deadline, and she could win by default. She was hoping to bury me in procedure and force me to make a costly mistake before the truth ever had a chance to come out. Her decision to take it to court also signaled something else. She was confident enough to believe the judge would side with her, or at least force me into some kind of settlement. Whether that confidence came from arrogance, ignorance, or both, I didn't know yet. But I did know one thing. This had gone far beyond neighborhood drama. This was now a full-scale legal battle, and if I didn't take it seriously, she might just get exactly what she wanted. I wasn't about to walk into court unprepared, so the first thing I did was pull out every single document related to my property. I dug through my closing paperwork, the deed, the title insurance policy, and the plat maps the county had on file. It didn't take long to confirm what I already knew. Nowhere, in any of those records, was there any mention of a homeowners association or a covenant that applied to my land. My property was an independent parcel, never annexed, never included in any HOA agreement. That was my starting point, but I knew I needed more than just my own word if I wanted to dismantle Karen's claims in court. I started researching how HOAs are legally formed and what paperwork they're required to file. I learned that for an HOA to expand its authority to new properties, there has to be a clear legal process, usually a formal annexation agreement that's recorded with the county and signed by the property owners involved. There also had to be proper notification and approval, both of which were entirely absent in my case. With that in mind, I went down to the county recorder's office to pull every public record related to Karen's HOA. What I found was eye-opening. The HOA's original incorporation documents were decades old, listing only the houses within a small development down the road. The plat map clearly showed that my street, my lot, and several surrounding parcels were not part of their boundaries. Even more interesting, there had been no amendments or annexation filings made in the years since. Legally speaking, their reach ended at the edge of their subdivision, and yet Karen had been acting as though she had jurisdiction far beyond that. Digging further, I came across meeting minutes from HOA board gatherings, publicly available because they had been posted online, that revealed Karen had been openly discussing expanding the association by encouraging nearby properties to join. The word encouraging was clearly a polite cover for what she was really doing, sending intimidating letters and issuing fake fines. These minutes didn't just support my claim that my property was outside their reach. They showed intent to stretch that reach without following legal procedures. I also took the time to speak with a few former HOA board members whose names I found in those meeting notes. Two of them were surprisingly willing to talk, and both confirmed that during their time on the board, there had been no legitimate process to annex my property or any others on my street. One even said they had raised concerns about Karen's aggressive recruitment tactics, but she'd brushed them off, insisting that most people don't know the rules, so they'll just go along with it. That statement stuck with me because it perfectly explained her entire strategy. She was counting on ignorance and intimidation to get her way. Knowing I had to back up my position with solid evidence, I organized everything into a binder. My property deed, plat maps, county boundary records, the HOA's own incorporation documents, and printed copies of the meeting minutes where Karen discussed expansion. I also included my correspondence with her, highlighting her threats and the baseless nature of her violations. The goal was simple: walk into court with a clear, chronological presentation that made it impossible for her to twist the facts. The more I prepared, the more confident I became. Every piece of evidence reinforced the truth that Karen's HOA had no legal authority over me. And beyond that, it exposed a pattern of overreach that could potentially undermine their standing entirely if brought to light in front of the judge. This wasn't just about proving I didn't owe her money. It was about showing that the entire lawsuit was built on false pretenses, and that the HOA's president had been abusing her position to bully non-members into compliance. By the time I was done with my research, I realized that I had something much more powerful than just a defense. I had the makings of a counterargument that could flip the entire case on its head. Karen thought she was dragging me into her arena, but in reality, she had just set the stage for me to expose every flaw in her HOA's claim to authority. The day of the court hearing, the air in the small county courtroom was thick with tension. Karen sat at the plaintiff's table, flanked by a lawyer who looked like he had been briefed on the case only a few minutes earlier. She wore a smug expression, as if she had already won, tapping her pen against a thick stack of printed violations and photographs. I walked in with my binder of evidence, calm but alert, determined to make every point count. The judge, an older man with a measured voice, began by asking Karen's attorney to present their case. Karen's lawyer launched into a rehearsed speech about how my property was subject to the governing documents of the association, and how I had willfully ignored repeated notices to comply. He gestured to the pile of letters, photographs, and supposed records of unpaid dues, trying to paint me as a defiant neighbor harming the community's cohesion. For a moment, it was clear the judge was simply listening without judgment, letting him lay out the narrative. Then came my turn. I started by handing the judge a copy of my property deed, highlighting the complete absence of any HOA references. I followed that with the official county plat map, which clearly showed the HOA's boundaries stopping well short of my lot. The judge studied it carefully, flipping between pages, and I could see his expression shift ever so slightly as the picture became clear. Next, I presented the HOA's own incorporation documents, which I had obtained from the county recorder's office. They explicitly named the subdivision they governed, and my address was nowhere on the list. I explained how there had been no amendments or annexations filed to legally extend their jurisdiction. I also included printed meeting minutes from HOA board gatherings, pointing to sections where Karen had discussed expanding into non-HOA properties without any formal legal process. That drew the judge's attention immediately, and he asked Karen's attorney to confirm whether such annexation paperwork had ever been filed. The lawyer hesitated, then admitted there was none. I could feel the momentum shift in my favor, but I wasn't done. I showed the judge the letters Karen had sent me, filled with references to non-existent clauses and fabricated fines. I also submitted sworn statements from two former HOA board members who confirmed there had been no legitimate annexation process. Their statements described how Karen had been told repeatedly that properties like mine were outside HOA authority, yet she continued to issue demands anyway. As I laid everything out, the judge began to ask more pointed questions. Not to me, but to Karen and her attorney. He wanted to know on what basis they claimed my property was within their jurisdiction, and when they could not produce a single legally valid document to back it up, the cracks in their case widened. Karen tried to speak directly, arguing that it's always been understood that our area was part of the HOA, but the judge cut her off. reminding her that legal authority doesn't operate on understandings or assumptions. Her attorney attempted to salvage the argument by suggesting that my property benefited from certain shared community amenities, and thus was implied to be part of the HOA. That claim fell apart when I explained, and showed in photos, that there were no shared amenities anywhere near my home. Everything on my lot was privately maintained, and there was no legal agreement tying me to any HOA resources. The turning point came when I explained how Karen's overreach wasn't just a mistake. It was part of a deliberate pattern. I referenced the other neighbors who had paid fines despite not being in the HOA, and the board minutes showing she intended to target more. I could see the judge's demeanor harden as he realized this wasn't a one-off misunderstanding but a misuse of HOA authority. Every piece of evidence I brought was methodically linked back to the core point. The HOA never had legal jurisdiction over my property, and every action they took against me was without foundation. By the time I finished, the judge had a complete, documented timeline showing how Karen had escalated her demands from baseless letters to a full-blown lawsuit with no legal standing. The weight of that evidence now sat squarely in front of him, and the courtroom felt quieter than it had all morning. Karen's confident expression had started to falter, her pen no longer tapping, as she realized the case was not unfolding the way she had imagined. The judge leaned back in his chair, flipping once more through the stack of documents I had provided. His questions to Karen's attorney became sharper, each one aimed directly at the missing legal foundation for their claims. "You have no annexation documents? No recorded covenant binding this property?" he asked, his tone no longer neutral but edged with disbelief. The attorney shifted uncomfortably, glancing at Karen, who now looked less smug and more restless in her seat. The judge pressed further, asking if they could point to a single piece of recorded evidence proving that my property was subject to their HOA's authority. The silence that followed was almost heavy enough to feel. When it was clear they had nothing concrete, the judge turned his attention fully to Karen. He asked her directly why she had issued fines, threats, and legal action against someone who was not documented as being under the HOA's jurisdiction. Karen started in with a long-winded explanation about community integrity, uniform standards, and how it had always been assumed that properties in my area would eventually join the HOA. The judge cut her off mid-sentence, reminding her that personal assumptions and neighborhood gossip do not constitute legal authority. From there, the proceedings moved quickly. The judge stated plainly that without legal documentation connecting my property to the HOA, their entire case was invalid. But he didn't stop there. He addressed the pattern of harassment, noting that the evidence suggested the HOA, under Karen's leadership, had a history of overstepping its boundaries with non-member properties. He made it clear that such behavior was not just improper but could have legal repercussions if it continued. Then came the decision that caught even me off guard. The judge declared that given the absence of proper records, the HOA as it currently stood lacked the legal foundation to operate in the manner it had been. He ordered it dissolved on the spot, citing structural and procedural flaws in its formation and ongoing conduct. The words hung in the air for a moment before anyone reacted. Karen's mouth fell open, her face flushing as the weight of the ruling sank in. Her attorney immediately began whispering to her, but the judge spoke over them, saying that his order was final unless successfully appealed, which, given the lack of documentation, would be a steep hill to climb. The courtroom was utterly still except for the sound of the clerk typing up the decision. I sat there absorbing the moment, realizing that what had started as an unwanted personal legal battle had now freed an entire group of homeowners from an overbearing and improperly run association. Some of those homeowners were sitting in the gallery, and I caught the slight nods and relieved looks they exchanged with one another. It wasn't just my win, it was theirs too. Karen, on the other hand, looked like she had just watched her power slip through her fingers. The carefully constructed image of her as the enforcer of the neighborhood had been shattered in front of a room full of witnesses. She avoided eye contact with me as the judge wrapped up the session, perhaps realizing that every move she had made to intimidate me had instead brought about the complete dismantling of her authority. As the judge exited the bench, the attorney gathered his papers quickly, clearly eager to leave. Karen stayed seated for a moment longer, staring down at the table, before slowly standing and walking toward the exit without saying a word. The sound of the gavel's final strike still echoed faintly in my mind as people began filing out of the courtroom. What had started as months of frustration, harassment, and escalating threats had ended with the most decisive outcome possible, one that no one, not even me, had seen coming when this all began. 21.